So let me kick off by looking at the difference between duress and undue influence. I'll then move on to consider in what ways are they similar, as I've indicated. So both of these concepts are ways to avoid or rescind the contract. In the case of duress, which is a common law defense to the enforcement of a contract, it indicates when its constituents have met, it indicates that the agreement is not enforceable because of the circumstances in which it came into effect. And there are three tests which I'll outline shortly. So the one important point there is, under the common law, if an agreement is seen to have been procured by duress, it can't be enforced. It's a defense to the enforcement of that contract. Undue influence, on the other hand, is a more nebulous concept which comes from the courts of equity. Of course, our courts now apply equity and common law together, but this is the starting point I referred to. So for undue influence, where the courts of equity found that a relationship had been tarnished by someone's undue influence, and therefore a transaction which had come out of that relationship had been tainted by the undue influence, it was a voidable or rescindable transaction, and therefore could not be enforced either. So the outcome is the same in these cases, but the concept and the way in which we're looking at it and the starting position, common law or equity, are different. Moving on to undue influence, I'm going to give you a comment or citation from the leading case on this, which is Ettridge against Royal Bank of Scotland, and what Lord Scott's judgment in that case. But before I do that, let me just explain. Undue influence typically arises in a relationship between people who are either related by blood or related often by marriage or some other social commitment. It's not unique to that, but that's where it often is found. And in the Ettridge case, all the cases involved, all the situations involved there were personal relationships, or often marriage relationships. Well, what Lord Scott said in that case in the House of Lords, and this is from 2001 when the judgment was given, so 20 plus years ago, he said, in the fairly common circumstance that the financial and business decisions of the family are primarily taken by the husband, I would assume that the wife would have trust and confidence in his ability to do so and would support his decisions. I would not expect it to be necessary to establish the existence of the trust and confidence. I would expect evidence to be necessary to demonstrate its absence.